Winding up of the companies, it needs grounds and effects. As we all are aware of this fact that now we have a new companies law, that is the Companies Act 2013, and it has replaced an old age companies law of 1956. In the new Companies Act, several new sections or provisions were inserted and several old provisions were deleted. We have total of 470 sections in the new Companies Act 2013. So, as my topic is winding up of the companies. So, a company is an artificial body, artificial as well as an independent body. A company, whenever a few members came together to form a company, then they have to go through a very huge process to establish their company. So, the question of winding up is very serious, because when the persons who are coming together to make their company, to establish their company, why they want to wind up their company. So, winding up is a process whereby the existing company's affairs are brought to an end. It is a very complex situation where the companies which came into existence aspire to grow higher with the passage of each day, in fact each second. They turn off their entire business, and this winding up can be voluntarily as well as can be compulsory. Voluntary winding up can be understood at the companies if the members of the companies want to end up their business. This is genuine, this is natural. But where the compulsory winding up came into question, then the question is why, what are the grounds, what are the factors which lead a company to wind up their business. So, basically it is a process by which the properties of the company are administered for the benefit of its members and creditors. You know, a company is formed not only by the members. There are few persons like creditors who invest their own money in the company, and if they invest their money, then obviously they want some good return after that of their investment. So, whenever a company fails to give them the good return, or whenever the company fails to satisfy their creditors, then that leads the very complex situation for the companies where they may face the winding up of their establishment. In winding up is also known as a liquidation, because here the person appointed for administering the assets and liabilities is called liquidator. If there is a compulsory winding up, then the liquidator is appointed by the tribunal, that is a company law tribunal, under section 275 of the Companies Act 2013. There is a new company law. In case of voluntary winding up, the liquidator is appointed by the company itself by passing a special resolution in a general meeting, and that is under section 310 of the Companies Act. So, on liquidation, the company's name is deleted from the list of the companies by the registrar of companies, and the same is published in the official gazette. As I already told you that there are two types of winding up: compulsory winding up and voluntary winding up. Compulsory winding up is also known as winding up by tribunal, because there is an involvement of tribunal in it. Section 270 of the Companies Act 2013 provides these two modes of winding up. So, now I will tell you the basic difference between these two modes of winding up, compulsory as well as voluntary. In case of compulsory winding up, petition is filed before the tribunal either by the company or by any creditor or by the contributory or by registrar or any person authorized by the central government on that behalf. This is section 272 of the Companies Act 2013, which provides the persons who can file petition in the tribunal for the winding up of the company. Whereas, in the case of voluntary winding up, section 304 of the Act provides that no petition is required, no petition is filed before the court or the tribunal. In this case, what happens? The company passes a special resolution in its meeting, or it passes a general resolution in case of expiry of the period of its duration. Suppose if a company is formed for a specific purpose, and to in the article of association, as we all know that the article of association and memorandum of association are two important documents for the formation of a company. If they have mentioned that they are establishing their company for a specific purpose, and after the completion of that specific purpose they will end up or they will demolish their company, then it is a very general or a genuine reason that when they complete their specific purpose, they will wind up or they will demolish the company. So, this is the voluntary winding up given in section 304 of the Companies Act 2013. Now, in case of compulsory winding up, the tribunal at the time of passing the order of winding up appoint an official liquidator. Please note that here is an official liquidator or the liquidator from the panel maintained by the central government. This is given in section 275 of the Companies Act 2013. Whereas, in the case of voluntary winding up, the liquidator is the company's own liquidator from the panel prepared by the central government. Here the panel is of the central government, but who appoints the liquidator? It is the company. This is given in section 310 of the Companies Act 2013. Third difference is that in case of compulsory winding up, the official liquidator can be removed by the tribunal on the grounds which are mentioned in section 276 of the Act. Whereas, in the case of voluntary winding up, the company liquidator can be removed by the company itself if it is appointed by the company, or by the creditor if it is appointed by the creditor, on the grounds mentioned in section 311. Now, as we all know that a company is established and a company is administered by two main vital organs. One is a member of the company, they are the directors or the shareholders, and another one is the creditor who invests their funds in the company. So, if the company itself want to wind up their business, then in that case company itself can appoint a liquidator, and if the creditors want to wind up this business, then in that case creditors have the right to remove any company liquidator if they want. Another main difference is that in case of compulsory winding up, the order of winding up of the company shall operate in favor of all the creditors and all contributories of the company as if it had been made out on the joint petition of creditors and contributories. This is given in section 278 of the Companies Act. While in case of voluntary winding up, section 309 says that the company shall from the commencement of the winding up cease to carry on its business except as far as required for the beneficial winding up of its business. So, this is the main difference between the compulsory winding up and the voluntary winding up, as there are two modes of winding up. It means that the winding up of the company can either be compulsory or can either be voluntary. Now, further, even the voluntary winding up is of two types. Again, I will repeat the same, that a company is administered by two main vital organs. One are the members of the company, the shareholders and the directors, and another is the creditors. And I had told you that voluntary winding up can be enforced by either the members or the creditors. So, the voluntary winding up is also of two types, members voluntary winding up and creditors voluntary winding up. In case of members voluntary winding up, declaration of solvency is made by the directors, while in case of creditors voluntary winding up, there is no need of such declaration. In case of members voluntary winding up, only meeting of member is called, while in case of creditors voluntary winding up, meetings of both the member as well as the creditor is called. In case of members voluntary winding up, the liquidator is appointed and remuneration is fixed by the company itself, while in case of creditors voluntary winding up, the liquidator in fact is appointed by the creditors and remuneration is fixed by the committee of inspection. In case of members voluntary winding up, no committee of inspection is appointed, and I already told that in creditors voluntary winding up, committee of inspection is appointed. In case of members voluntary winding up, the liquidator can exercise some powers with the sanction of a special resolution of the company, while in case of creditors voluntary winding up, the liquidator exercise powers with the sanction of the tribunal. In case of members voluntary winding up, meeting of members is called on completion of procedures or proceedings of winding up, while in another case, that in the case of creditors, meeting of members and creditors is called when the proceedings for the winding up has been completed. So, these are the main difference between the members voluntary winding up and the creditors voluntary winding up. So, till now we have discussed the concept of winding up, what is the winding up, the two modes of winding up, that is the voluntary winding up and the compulsory winding up, and the two further modes of voluntary winding up, that is members voluntary winding up and the creditors voluntary winding up.